I'm very pleased now to introduce you to our presenters today. Rob Mink, Principal at Meridian Lawyers. Robert is highly regarded for his decades of experience in insurance law and has a strong track record of success in managing public liability claims, personal and property damage, property subrogation, subrogated recoveries and abuse claims. His client experience is broad, including representing one of Australia's largest general insurers, Lloyd's of London syndicates, university supermarkets, state government councils, professionals, transport companies, and the operators of large infrastructure and building projects. He has represented Unimutual in a range of claims, both defending claims and subrogated recoveries for the last 10 years. Robert is acknowledged for his experience in personal injury law and is listed by Australasian Lawyer in their 2022 list of 5-star personal injury lawyers and law firms. He was named Lawyer of the Year in 2021 in the category of Personal Injury Litigation by Best Lawyers Australia, and has also been recognised by Best Lawyers Australia as a leading lawyer since 2014 in the following categories: insurance law, personal injury litigation, and product liability litigation. Doyle's Guide has also acknowledged Robert's expertise since 2018 as a leading defendant, public and product liability lawyer in their 2022 edition. Robert will share his insights on the critical aspects to consider when an incident occurs and the elements that need to be circumnavigated to resolve a claim to reach a favourable outcome for the client. We also have Shannon Money, Principal at Meridian Lawyers. Shannon is highly regarded for her insurance litigation expertise. She has provided extensive advice to numerous Australasian international insurers, brokers and underwriting agencies in defending claims and advising on wider insurance indemnity issues. She has acted for Unimutual for more than 7 years. Shannon has acted in a variety of medico-legal, professional indemnity and property damage claims, in addition to regularly acting for medical hospitals and medical allied health professionals. She also defends claims on behalf of different professionals, including engineers, real estate agents, accountants, construction contractors and insurance brokers. Shannon is experienced in dealing with a wide variety of claims made against universities, including personal injury, property damage and recovery claims, as well as student complaints. Shannon is recognised by Best Lawyers Australia as a leading lawyer in insurance law. Shannon has a successful track record in resolving claims and will share her experiences and highlight the nuances of the litigation process for claims that run to trial. I will now hand you over to Robert to start the presentation. Thank you.
Thank you very much, and thanks for everyone for attending this afternoon. Hopefully you'll find this presentation helpful and give you some ideas about how we deal with claims and why we ask you questions about claims and pretty much the whole claims process from the beginning to the end. And that's why we've called it the life cycle of a claim. Obviously, I need to make a disclaimer that whatever we've given you does not constitute legal advice. But you know, if there's anything after this presentation that you don't wish to raise publicly and you want to have a chat to us, we're more than happy to talk to you. We thought we'd leave questions to the end, but if you know there's anything that comes up during and you want to put a question on the webinar, I'm happy to see whether it's something we can answer during the presentation or at the end. So just to provide an overview, what we're looking at is, and we're going to look at I suppose an example, what happens immediately following an incident, what information lawyers and or Unimutual may need to investigate the incident and why. Often, because I'm sitting, or Unimutual, we're sitting in an office and we're not there day to day, we often need to retain factual investigators or loss adjusters, why the communications need to be managed carefully, then the claim, the litigation process, and in particular the discovery and interrogation process, and why it's important to get this right, the mediation process, factors that are involved in determining whether to run a matter to trial, the trial process, which differs from state to state. For example, in Victoria, we've got a jury system which can be accommodated, and I'll talk to that a bit later on. And then the factors we look at in resolving a claim. I'll pass over to Shannon.
Thanks, Rob. Hi, everyone. So I'm just going to make a start talking about what happens immediately following an incident. Now, an entity, and potentially their lawyers, depending on when they get appointed, will very much be on a gathering evidence and fact-finding mission at this point in time. The types of claims we assist Unimutual with are varied. It goes without saying, but for today's purposes, we are going to focus on the very straightforward example of a visitor who has attended a member's grounds and has fallen on some stairs. So it's a nice, simple example. Obviously, the first step following a fall of this type is to focus on the person's well-being. So are they okay? What immediate medical assistance do they need? And who is required to be called, ambulance, etc. What other services do they need? The second priority is to complete an incident report. Now, this should be as detailed as possible, including the date and time of the incident, how the incident occurred. If the injured person is able, a description from them directly as to what's happened is very useful. Any photographs of the incident site at the time of the incident. Any witnesses to the incident, so what we would be looking for is their name and contact details, and also information about their position, so if they are a staff member or if they are a third party.
Shannon, there's one other point I wanted to add to that, and that is when you're providing an incident report, it's quite important that it's a factual record of what's happened. And it's preferable that in those incident reports, you don't put in your opinion of what happened, because that can often harm the defence of a claim down the track when maybe there's no reason for it to be harmed. So often we'll get an incident report and it says, oh, well, we should have done this and we should have done that. And that may be the case, but it may not be the case once you dig deeper into the incident. So it's really important that the incident report is factual and does not contain opinion. Sorry, Shannon.
And hypothetical conclusions. I think that's a very good point you raise, because it can be difficult if we are dealing with it from a defence perspective to have to then provide that incident report to the other party, and then they obviously immediately latch onto some opinion that might not be correct, but we have to overcome that and effectively do damage control. And then finally, just a description of what's happened based on everyone's observations to the incident. And if nobody's witnessed what's happened, obviously that can just be limited to the injured person's account. So we're just moving on to the next slide. So as previously stated, we described this phase of the claim as being a fact-finding mission. In order to be in the best possible position to manage a claim, it's important for Unimutual and its lawyers to have contemporaneous documentary evidence and observations of the incident. This is obviously the most valuable type of evidence because we all know that memories fade with time, and relevantly, it can often take a very long time for a formal claim and litigation to be commenced. It can be months, if not years, before you see any progress in this respect. Sometimes Unimutual may appoint lawyers before a formal claim is on foot. So what I mean by that is there may not be litigation on foot or there may not be a formal letter of demand. But if there's a level of complexity of issues and the nature of the incident means that it's important to be on the front foot. For example, we think that it's going to be a very high quantum claim, obviously fatalities and or a very significant or serious injury, then it may well be worth appointing lawyers early. So generally, going back to the fall down the stairs example, we would generally be appointed in those types of circumstances after a member has received some form of written communication from the injured person, not necessarily a formal letter of demand, but just expressing their intention to claim compensation or seek recourse for the incident. Now, as we're on a fact-finding hunt at this stage, the types of things that we will be asking members for includes relevant policies and procedures that may be in place at the time. In the case involving the stairs, we'd be looking at whether they comply with various standards, but we'd also be closely analysing the circumstances. So, for example, if the incident occurred in the evening, lighting by the stairs might be relevant. The weather could be relevant. If it was raining, we may be looking at the grip on the stairs and whether that was sufficient. And maintenance. So if there's an issue with maintenance of the stairs, we'd be looking to explore that further. Another aspect we would be asking questions on is, are there any contracts or agreements that the member might have with third parties that may be relevant to the circumstances of the claim? So this would be for the purposes of investigating and seeking contributions potentially from other parties. So for example, a third party may be responsible for maintaining the member's grounds, for example, cleaning or maintaining the stairs. And sometimes incidents also occur at a specific event being held on your grounds, and you'll have engaged third parties to organise and be responsible for that event. So it's necessary for us to carefully review those agreements in place. And the purpose of doing that would be to work out what the parties' intentions were in terms of apportioning responsibility for the event and consequent liabilities. In certain property damage claims, for example, those involving research samples, in order to quantify loss, we may need to ask specific questions of various academic staff members to verify what loss has been substantiated. We'll also ask a lot of questions about who might possibly be involved in the incident, or can answer questions about the overall factual matrix. And the question we will rarely be focused on is who will be our key witnesses if a formal claim will be pursued. Once we've identified those key witnesses, the next step will be for us to obtain witness statements. And this involves setting up meetings individually with each of those identified people. And we all know, as I've said before, that memories fade with time, so it is best to preserve that evidence while the incident is still fresh in all of their minds. And it's also important to note that people move on, they retire, and noting that it can be quite a significant time lag, it's useful to get those witness statements sooner rather than later. And then just finally, preservation of documentary evidence is also important because sometimes obviously individuals might have made personal notes about things, and we also, in the case of, for example, equipment failures, we need to make sure that that is actually preserved, because we may well need to get that inspected or reviewed by any experts that we appoint later down the line. And another good example is CCTV footage. Because this gets wiped regularly, it's important for us to obtain that relevant footage so that it is stored appropriately for when we need to look back at it. So we're just moving on now slide-wise to, we should be going on slide 6. Why do we need to notify Unimutual? So an early notification to Unimutual is important because it enables Unimutual to make a determination as to what further investigations should be undertaken now or later, going back to what I've just canvassed. And then whether the incident is also serious enough to retain factual investigators and or lawyers to investigate. And Rob's going to talk more about the role of factual investigators and the need to maintain privilege a little bit later on. Often with complicated claims or those involving multiple parties, the earlier we get to the bottom of the facts, the better, because as we work through that investigation stage, we'll also be ascertaining where liability should actually fall, and we'll also be carefully considering rights of contribution. An advantage of getting to the bottom of these issues quickly is that you can work out who the correct party to be sued is. So while plaintiff lawyers won't always listen to us when we try to direct them on that issue, because there are some plaintiff lawyers who'll just cast the net as wide as possible and just name a bunch of individuals at the outset. We can often influence them at that very early on stage to ensure that the correct parties are being pursued and that the claim is not overly messy for no reason. Because if there are people who have been joined unnecessarily, it can be very time consuming and costly obtaining everyone's consent to later let various parties out of the litigation. So I'm just going to raise a case example at this juncture. A few years ago, we were asked by Unimutual to defend a medical malpractice claim that had stemmed from an incident that occurred at a clinical school. And after a lot of investigative digging at that very early stage, we were able to ascertain that the student was not actually enrolled at the university, and the matter required some extensive disentangling due to the way that placements were managed at the clinical school. But because we got to the bottom of that factual matrix very early on, we were able to redirect the claim completely to another entity entirely, and we were able to avoid any formal claim being pursued against the member at all. So if proper investigations hadn't been undertaken at that early juncture, it would have been very easy for the claim to have been misdirected and for the member to have unnecessarily been drawn into litigation. So moving on to slide 7, why do we ask? I've already covered a lot of these reasons that we ask for so much information at the outset. I just want to add that strategically, it can be beneficial to assess a claim fully very early on. So if necessary, we may consider that there are just obviously no or very low prospects of defending a claim based on the evidence. And in those circumstances, we would look at settling the claim informally and potentially even prior to proceedings even being contemplated or initiated. This has a direct effect on the member's loss ratio and potentially under contributions that are charged. I'm now going to hand back over to Rob, who will talk about the role of factual investigators and loss adjusters.
Thank you. So factual investigators for insurers and insurance lawyers are very important because what they are able to do is go out to site in probably a more cost-efficient way than lawyers can do, and condense all the relevant information about the facts of an incident into a report. And as I said earlier, I'm sitting in an office in the city, and it's going to be more cost effective for them to provide me with a report. And based on that report, when I've got all the sort of the background information, we may say to the factual investigator, well, we need you to go and get this and we need you to get that. Or, you know, we use that as a basis to then take over and conduct some more bespoke investigations that we need to conduct to get to the bottom of an assessment of the liability exposure or of the claim. Often lawyers, and I'll talk more about privilege in a minute, but we retain factual investigators to maintain legal professional privilege. So you'll get, the process is this, you know, Unimutual have been notified of a person who's fallen over at the university. They're anticipating that there might be a claim, and they want some advice from their lawyers about what the exposure to the claim might be, and they also want to make sure that the circumstances are obtained relatively quickly after the fact in order to collect as much information as quickly as possible, given, as Shannon has said, that as time goes on that becomes more difficult. So the factual investigator will be retained by Meridian lawyers. Meridian lawyers will write to the investigator and say, please go and undertake X, Y, and Z investigations. Please address your report to Meridian lawyers. And then we take that report and we use that report to provide legal advice as to the exposure that Unimutual and or the university might have to the claim. Now, the reason that we do it that way is because often in these reports, they are critical of the member, the Unimutual member, or they may not be. But if they are critical, it means that that information is not discoverable, and we know what the position is, but we don't necessarily have to share that with the opposing side if we choose not to. And that can include statements that are obtained by the factual investigator for the member. Now, the factual investigators and loss adjusters often do the same thing, but a loss adjuster is a little bit different generally and more in the property damage space. They're there to quantify a claim. So their expertise is to go in, look at what the damage is, and provide a quantification of that damage. Often factual investigators and loss adjusters are the same people, but often if I'm doing a subrogated recovery, I may wish to retain separate loss adjusters and separate factual investigators, because the factual investigation I know will need to be privileged, and the loss adjusting, which might be used initially to assess the primary claim, might need to be discovered down the track in a subrogated recovery. So if we are going to disclose those loss adjusters' reports and it's a different loss adjuster, we don't compromise the privilege over the factual investigations. Can we go to the next slide, please? So it's really important that the member cooperates with these individuals in order to give lawyers and Unimutual the best information possible to assist with the claim. Difficulties can arise if we're sort of drip-fed the information, because this can ultimately lead to an increase in the costs of the claim and cause logistical difficulties if people have moved on. And we want to get as much information as early as possible so that there are no surprises. So if we get some information and not everything that we've asked for, and the litigation continues on, and we've originally thought maybe we had a good defence to a claim or a good subrogated recovery, and then further information comes up later that we could have got earlier that puts that in jeopardy, well, we've wasted a lot of money. So that's why it's really important to get as much information as quickly. Can we just go back to the slide? Yeah, so the last point I wanted to make just there was, especially if you're a member where you've got a large self-insured retention, that what I was going to say is especially relevant. Next slide, please. So what's the difference between legal professional privilege and litigation privilege? So sometimes Unimutual won't instruct lawyers, and they'll just go straight to a loss assessor or a loss adjuster, and they often are able to maintain privilege over any such report they receive on the basis of what's called litigation privilege. And in order to be able to establish litigation privilege, you pretty much need to be able to assert that the dominant purpose of obtaining that report was in relation to actual or anticipated litigation. So they can often maintain privilege in that regard. Legal professional privilege is different, because legal professional privilege is where the report is obtained by a law firm, and they directly retain the factual investigator or the adjuster, and they're using that report for the purpose of providing legal advice. So it falls within the bailiwick of legal professional privilege. Often we'll be instructed after Unimutual have obtained reports. And as I said, if it's a subrogated recovery involving property damage, the only way really to substantiate the quantum aspect of the claim is to disclose those quantum reports. So sometimes what we do is we'll disclose the reports in a redacted form, so we can maintain privilege over some of those reports, and/or not other parts of that report. So expert opinion. This is also an important issue. So often, if let's use an example of a personal injury claim, and someone's tripped over a stair, for example, or they've fallen down a stair. So we might need to get an expert to tell us whether that stair complied with appropriate regulations, and if it did, well, that's good. If it didn't, if, say, for example, we're an occupier of premises and we retained other parties to design that stair, we might want to think about joining those parties. Now, there's I'm not going to go into it in a lot of detail, but there's quite a lot of varying rules around expert opinion. In Victoria, you can go and get a liability, let's use personal injury, you can get a liability expert, but not necessarily serve that opinion. That is not the case in other states, for example, Queensland. However, if it's a quantum report and it's a report on someone's injury, and that doctor goes and undertakes a face-to-face assessment of the patient, we have to serve the report. So the point that I'm making is that it's really important to be very clear about the communication that we have with experts, so as to try and avoid material being unnecessarily disclosed. And if we are writing to you in a very legalistic way about how we want you to provide us with information or how we want you to talk to an expert, that's generally the method behind the madness. It's very important to give careful instructions to experts about what you want them to opine on, and very important to give considerations to the documentation you're going to give them with careful planning on any conferences to take place between the lawyer, the expert, and the member, the detail of which could be discoverable in a court proceeding. So that's why we're very conscious about the way we communicate, not only with loss adjusters, but also with the experts. Over to you, Shannon.
Thanks, Rob. So we're starting to talk now about the litigation process. Let's go back to that stair fall example. We've completed our investigations, we've gathered the necessary evidence, we might have some witness statements signed and on file, and it may be that we've written to the claimant solicitors denying liability for the claim. What happens next? Well, in some cases, the claimant solicitors might listen to the points that we've raised when refuting liability, or it could have been just a try-on claim in the first place, and litigation might not actually follow. And in those cases, obviously that's the best outcome. We can simply close our file and no further action is necessary. However, despite telling a claimant solicitors a claim will be defended, they will often have their own ideas about the merits of the case, and litigation will be initiated. So the first step in that litigation process is for the filing of a writ of summons, followed by the pleadings being finalised by the parties. And typically, the pleadings consists of a statement of claim, which is prepared by the plaintiff, and a defence, which is prepared by the member. These documents include the details of the claim or the defence that the parties are making and the facts that underlie that claim or defence. And the purpose of the pleadings is to identify to the court and to the parties themselves the key issues for determination of the case. Pleadings effectively present all allegations of facts that are relevant to the case, which the parties will need to prove if the matter runs to a trial. Now, once the parties have filed their pleadings, most states have some sort of case management process involving the court setting down a timetable for the various stages. That's discovery, interrogatories, the exchange of expert evidence, the serving of particulars of damages, which is a document that quantifies the claim that's being brought. And then followed by that, generally, there's some form of compulsory mediation. While the case management process is stipulated by the courts, this doesn't actually mean that the parties have to wait until that compulsory mediation stage to consider resolution of the claim, and attempts can and should be made to settle at any stage if there's good reason for early settlement. The case management process differs significantly from state to state, and this includes everything from terminology, we just call things by different names, to the actual underlying process. The WA system over here is much more relaxed than other states, which can be a source of frustration for us as defence lawyers. There's often quite significant delays between, for example, us filing and serving a memorandum of appearance and then the litigation actually gaining momentum by the statement of claim being served. So the plaintiff over here in WA is supposed to file and serve a statement of claim within 14 days, but we often see this time frame just being completely ignored and overlooked. And it can actually, in fact, sometimes take up to a year before that statement of claim becomes stale for it to be served. And the only remedy rarely available to us in these types of situations would be to apply to the court seeking early programming orders. But we very rarely do this, as the outcome it would produce is simply the plaintiff seeking more and more time from the court in any event. So the practical upshot of this is that over here in WA, we usually use the delay to our advantage and either extend or commence the investigation phase that we've previously gone through. So discovery is a really important part of litigation and one that will require your active involvement in the claims process. Discovery forms the basis of the documentation that the parties will rely on in attempting to bring or defend a case. Broadly speaking, it involves two steps: preparing a list of documents that fall within agreed categories, and then providing inspection and physical copies of those documents to the other party. The exception to this is privileged documents. And in turn, we're given access to the other party's documents too. Now, preparing a list of documents can be a major exercise. It is the member's responsibility to undertake a thorough search of all documents and provide these to your lawyers for review. It can be a very time-intensive exercise. It can involve your IT departments needing to undertake extensive searches on your database. And it's really important that adequate resources are dedicated to this task and that staff members are directed to take this responsibility seriously. The term document is very broad. It includes paper records, for example, letters, file notes, memoranda, reports, invoices, receipts, accounting records, books, etc. And it emails. It also comprises information in other media. So, for example, computer disks, memory cards, film, videos, tapes, DVDs, probably not so much these days, and importantly, CCTV footage and emails, as Rob has referred to. So it's important that relevant documents are not withheld or destroyed, even if those documents are adverse to your position. And whether a document is relevant largely depends on the pleadings, so the factual allegations. And this is an exercise that we as lawyers advise on. So we always say to members, give us everything within these parameters and we'll advise you on relevance. A parties list is required to include all documents within their possession, custody, or power. And this particular phrase captures the documents you hold, whether or not you have a legal right to hold them, documents another person holds in circumstances where you would likely be able to obtain them if required. So a good example is an accountant's file. And then documents which at some point were in your possession, even though this may no longer be the case. There are some documents, as I've mentioned, that don't have to be disclosed, and reasons for not showing documents include privilege, so correspondence with your lawyers, and in some cases there are confidential, commercially sensitive information, but we find that this occurs rather infrequently. And then we've also got without prejudice communications. So that is correspondence regarding settlement discussions that you've had with the other side. Obviously, those don't have to be included. Discovery is a central part of the litigation process in Australia, and the courts do treat a failure to properly comply very seriously, and quite significant adverse findings can follow from any failure. So it's important to cooperate with your lawyers throughout this process. It's also important to note that it's an ongoing obligation. So if a document or a set of documents come to light after a discovery list has actually been filed or served, it's necessary to give the other party copies of the new documents by way of ongoing discovery. And sometimes, depending on how many additional documents are discovered, your lawyers might advise you that a supplementary list of documents should be prepared. Moving on to the next slide, please, let's discuss the interrogatories stage. So interrogatories allow a party to administer a series of written questions on another party. They are required to be answered to the best knowledge or belief of the party who is the subject of the interrogatories, and an affidavit verifying those answers is required. These answers can be tendered as evidence, and the person who has answered the questions can also be cross-examined at trial as to the veracity of the answers provided. Well-drafted interrogatories can force a party to make admissions that are damaging to their case, and poorly drafted interrogatories will often either be successfully objected to and remain unanswered, or they'll have little forensic utility. Again, this is a process that requires a member's active involvement. In answering interrogatories, you must make inquiries of your servants and agents, including former servants and agents. And the deponent of the affidavit is also required to answer in accordance with the information supplied to them based on their own knowledge, information and belief, but also on the basis of what they've been informed. Now, this
Can I just add, just with interrogatories, it's really important to get them right, because if your opponent's got interrogatories that are inconsistent with their stated defence or prosecution of a claim, that can be used in cross-examination to drive a wedge into their case. So it's really, because you can get cross-examined on your answers to interrogatories. Sorry, Shannon. Just thought I'd throw
That's all
that
right.
in.
All good. Now, this hasn't been included on the slides, but I also just wanted to mention that once we've seen what the other party produces by way of discovery and or interrogation, we may also consider the issuing of subpoenas. There's obviously a need to be pragmatic here, and we generally only do this if there's some important missing evidence. We have to strike a balance between trying to obtain important medical evidence versus simply just going on a fishing expedition. So an example could be if there's been a fall, going back to that stair fall example, and the outcome of the injuries is much larger than what one would have expected, it may be necessary to look at all of the medical history of the plaintiff. And further embedded discovery can also be explored at that juncture, and this could be an alternative to subpoenas if the evidence we require is in the plaintiff's control or possession, and they haven't provided it the first time. So moving on to discuss mediation, all courts nowadays generally have some form of compulsory mediation. The aim is to try and increase the number of disputes to ensure that they're settled more quickly and it's less costly, and this also helps reduce pressures on the courts more generally. We see as lawyers the vast majority of claims settling at this stage, and the reality is that we're just seeing less and less claims go to trial, primarily due to the cost of running them. In WA, we have pre-trial conferences. They're not quite mediations. Essentially, the parties are left to their own devices, and the court simply facilitates a time and place for them to discuss the claim between themselves. Court registrars can be drawn into that process if necessary. And generally at mediation, the parties engage in a discussion about the merits of their case. There might be a discussion about the expert evidence. Either the reports have been formally served at that point, or they've just been relied on an off-the-record basis. And at the conclusion of this process, the matter is either settled or listed for trial. So I'm going to hand back to Rob now to talk about running matters through to trial.
Thank you. So there's a number of issues we look at in terms of whether we want to run a matter to trial. Obviously, the big, I always say to people, the big problem with trials is you lose control. You can often lose control when you're in court, and that's because humans get involved. So it's not just looking at a statement on a piece of paper. It's actually how a person is going to come up and cross-examine or present as a witness. So in looking at the prospects of successfully defending a claim, we'll look at how our witnesses are going to present, how we think the plaintiff's going to present, the quantum of the claim. I mean, if it's a $50,000 claim and there's some risks involved, and it's going to cost us $40,000 to defend the claim, and we may not get any of that money back if we win because the plaintiff's got no money, maybe we're better off paying a little bit more to settle it. If it's often, plaintiff settlement expectations, we might think the claim's worth $100,000. We know we're liable, but the plaintiff wants $1 million. So then we might look at, well, maybe we put in cost protection, known as an offer of compromise or a call to bank letter, and we try and run the claim, and we run the claim basically based on quantum. All of that, we look at the costs of the trial, we look at a balancing exercise on all of the above. As an example, I had a claim that ran about a month ago in front of a jury. A person tripped over some pebbles at a motel. We thought we might be found liable, but we offered the plaintiff $100,000 plus costs in an offer of compromise, and they didn't accept it. And we balanced, well, maybe we won't be found liable, and if we are found liable, maybe she won't get that much money. So we ran the case, and actually we won. So we beat the offer, but we won the case. So they're the type of things that you're thinking about in terms of deciding whether to run a matter all the way to trial. Next slide, please.
One thing, Rob, I'd just add is also having self-represented litigants can be another factor in terms of deciding strategically how to best resolve a claim.
Yep.
Because that
and
can
often
obviously
self-represented litigants aren't particularly good at resolving claims, and they want their day in court.
Exactly.
They're not very good at making a decision. So depending on the state, the trial process goes like this. A judge or a jury will consider the evidence led by each party and then make a decision. In most cases, a judge will reserve their decision and produce written reasons, usually within a few months. I've seen over a year following completion of the trial. If a jury, then they'll deliberate and they'll provide a verdict shortly thereafter without written reasons. If you don't get written reasons, it makes it harder to appeal. If you've got written reasons, there's more of a chance of being able to appeal if you're not happy with the verdict. Again, you'll have to look at all the cost-benefit analysis of appealing. The trial proceeds as follows. So the only state, I should say, that does have a jury at the moment in civil matters is Victoria for personal injury claims, and it's 6 people. In a criminal case, it's 12. But I'm not talking about criminal matters for the purposes of this presentation. The trial proceeds as follows. The plaintiff's barrister provides an opening, which is a summary of all the aspects of the evidence regarding liability and quantum they'll need to prove their case. The plaintiff's barrister calls all witnesses and experts to give evidence, starting generally with the plaintiff themselves. Each of those witnesses are cross-examined by the defendant's barrister. Next slide, please. The defendant's barrister opens their case and provides a similar summary to that of the plaintiff in defending the case. The defendant's barrister calls all witnesses and experts to give evidence, starting generally, I've got there, that's a typo, not the plaintiff themselves, but with the defendant's lay witnesses. And they're, again, cross-examined by the plaintiff's barrister. The defendant's barrister then closes the case. The plaintiff's barrister closes their case, and that's generally running through all the evidence, generally in a way that, you know, presents their client in the best possible light. If it's in Victoria, after that, the judge charges the jury, and that's basically a commentary on what the jury process is, what evidence, what's been said in the trial, and what they can consider, what they should consider. The judge, as I said, reserves their decision, and once a judgment is made, there's an argument on costs, depending on what cost protection each party has put in or not. If this applies if, I suppose, the matter doesn't go to verdict, but if we resolve a claim, it's normally done by way of a deed of settlement and release. Often Unimutual members like to see the release and have some input into the release before it's signed. We're often, if we're defending a claim, it's very hard to, you're often looking for a non-admission of liability and confidentiality and non-disparagement clauses. If it's a personal injury matter, we try to get a Centrelink clearance because we don't want to be exposed to any payments to Centrelink that we otherwise weren't aware of. And we also need to get a Medicare notice because the Commonwealth legislation introduced by Paul Keating, for those who are old enough, said that, well, if someone else is negligent for Commonwealth funded healthcare, they can pay the Commonwealth back. And that's basically what the Medicare refund is about. So most cases, if they are resolved, they don't go to trial, and they're settled by way of a deed of settlement and a release. And I think that is the end of the slides, and that's sort of how a claim goes from go to woe. So if anyone's got any questions of us, we've got a few more minutes. We wanted to leave a few minutes for questions, and we're happy to answer them.
Great, thanks, Rob and Shannon. Thanks for all that information. That was great, and we'll just wait for some questions to come through. This is your opportunity to get some questions answered. Rob, I mean, and Shannon, you've been sort of dealing with Unimutual claims for quite some years. I'm sure you've come across some very interesting type of claims. Rob, can you give us an example of an unusual claim that you've had to deal with on behalf of a Unimutual member?
I can give you an example of many unusual claims that I've had to deal with, but one that springs to mind is a freezer that broke down, and it contained Antarctic ice poles that were to be used for research. And the issue was around whether the researcher needed to go back to Antarctica to take the research again, or whether that could be done in another way. So that was a pretty interesting claim. I've had cases involving PhD students who've obtained their PhD, but a member has thrown out all of the PhD samples that were used as part of that. We've had, people leaning on. We've just resolved a matter quite well where a person leant on a handlebar in a lift and it broke, and they injured their back quite substantially. So does that give you enough variety?
Yeah, no, that's great, Rob. Thank you. Shannon, have you come across anything that that sort of sticks in your mind?
It's always a bit of a mixed bag. We see everything from sometimes health claims. So we've had practitioners who are operating within a clinical environment who are being supervised by tutors do something wrong and are sued as a result of that. We have a variety of student complaints at any given time, and those can be pursued in a number of different jurisdictions. So it's not just civil litigation that we look at, but it can be allegations of discrimination, which are brought in the Human Rights Commission or the Equal Opportunities Commission. We have a variety of freezer malfunction claims and, you know, always very interesting medical scenarios. So I think the importance from a risk perspective is that members are always looking at these things from a variety of angles. And it is not just, you know, your run-of-the-mill slip and trip claims that we see.
Great, thanks. And Rob, you were talking about trials that go to a judge or a jury. What are the sort of nuances between the different types of trials that are run?
So a jury trial, it takes longer because often the barristers need to explain things more slowly and in more detail than they otherwise would to a judge who understands the process more. So that's a factor because it can cost more money. But we often look at, is this the type of a claim that a jury can sort of understand and comprehend and come to quite reasonably? Or is this a really complicated claim? And if it's really complicated, then you run the risk of the jury coming up with a sort of an unexpected decision. So often in the simpler claims where, you know, someone's fallen over and you think that the plaintiff's being completely unreasonable, I tend to prefer a jury to make a decision on that because I've got more faith in 6 people, you know, in the community making a decision than a trial judge who is part of the process and maybe doesn't see things as authentically as perhaps 6 lay people. So, for example, that case I was talking about where the lady tripped over on the pebbles at a motel, we just sort of looked at it and went, well, they didn't have any expert evidence to say there was anything wrong with the pebbles, and it was a pretty innocuous incident. She just fell over, and maybe a jury of 6 people of the community will go, well, just bad luck, and why are you wasting our time for 5 days in the county court trying to get some money out of an insurer? And it turned out that way, which was good.
How does that selection process work, Rob?
The selection of the jury?
Well, between jury or judge.
Oh, well, so we put in a jury notice, and sometimes once you've put in a jury notice, you can decide whether you want the jury or not. The plaintiffs often don't want juries because they think they'll get a better run in front of a judge, and the defendants often want juries because they feel that they'll get a better run in front of a jury. And then there's a jury selection process before the trial starts. There's a jury pool. People have to stand up to say whether they've got a conflict or there's any other reason why they can't appear. They can't be in a jury, and the judge will either accept that or not. So yeah, there's a few decisions that need, and then you have to sit in the room with the barristers and decide and choose the jury, and look at the people and try and decide who's going to be most appropriate for you. And each side's got can object to various jury members in order to form the jury that ultimately sits to hear the trial.